You have worked your whole life for what you own: the home, the farm, the savings. In Missouri, protecting it comes down to one decision that pulls in two directions at once. Keep total control of everything today, or lock it inside a legal fortress for tomorrow. Most of the time, you cannot have both. Here is how that choice really works under Missouri law and where the line falls. 5 things. The Missouri trust landscape, the revocable trust and the control it gives you, the irrevocable trust and the protection it buys, the trade off between them, and how to change a trust that is supposed to be unchangeable. Start with the ground you stand on. Missouri has quietly built one of the strongest trust codes in the country. It lives in Chapter 456, the Missouri Uniform Trust Code, modernized aggressively to attract trust business. That code opens with a rule that surprises people. A Missouri trust is revocable by default. Unless your document says in plain terms that it cannot be changed, the law assumes you kept the power to revoke it. Before we compare the two kinds of trusts, get clear on what asset protection actually means. It is organizing how you own things, using lawful structures and exemptions to reduce the risks you can see coming: lawsuits, creditor claims, the cost and delay of probate. It runs on timing and full transparency, lawful planning, done early, in the open. The everyday workhorse for most Missouri families is the revocable living trust. If you want maximum flexibility, this is where you start. The mechanics are simple. You are the grantor. You transfer the title of your property, the house, the accounts, even a ceremonial $10 bill, into the trust. Usually you serve as your own trustee while you are alive, because the trust owns the assets, not you personally. Nothing is titled in your name when you die. Probate is bypassed. That buys 3 real advantages. You keep complete control and privacy while you are living. You skip the slow, public, expensive probate process, and you get clean incapacity planning. If you can no longer manage your affairs, the successor trustee you named steps in immediately with no court-appointed conservator. Married couples get an extra tool in Missouri, the qualified spousal trust. Think of tenancy by the entirety as a force field around marital property. A creditor of one spouse cannot reach the family home. A qualified spousal trust lets a couple move that property into a revocable trust, avoid probate, and keep the entirety's protection intact. But control cuts both ways. Because you can pull the assets back out at any time, the law says your creditors can reach them too. Outside of that spousal protection, a standard revocable trust shields you from nothing. Not your own creditors. Not a Medicaid spend down. When you need a real wall between your assets and the people who might come after them, you need the irrevocable trust. Here, Missouri is unusual. It is one of only about 17 states that let you protect your own assets in a self-settled trust. Missouri calls it the Missouri Asset Protection Trust. The engine inside it is the spendthrift provision. For most of legal history, a spendthrift clause could only protect someone else, to lock money away from a reckless heir so a creditor could not touch it. You could not do it for yourself. Missouri reversed that. You can now shield your own assets. But the wall only holds if you build it exactly to code. 3 requirements. 1. The trust must be truly irrevocable. You cannot keep the power to cancel it. 2. It must contain a valid spendthrift provision. 3. Any distribution back to you must be fully discretionary, decided by the trustee, never demanded by you. You surrender direct control. In exchange, you gain protection your creditors cannot breach. Now put them side by side. Picture a chart. Across the bottom, how much control you keep. Up the side, how much protection you get. A simple will sits in the low corner with little of either, and it still drags you through probate. A revocable trust sits far to the control side. High flexibility, low protection. An irrevocable trust sits high on protection, low on control. 2 opposite corners. The revocable trust gives you maximum flexibility and no shelter from your own creditors or Medicaid. The irrevocable trust asks you to give up direct control and hands you strong creditor and Medicaid protection in return. And one option sits high in both corners at once. For married couples, the qualified spousal trust keeps full control and preserves entirety's protection. It is the closest thing Missouri has to both. Underneath these two umbrellas sit specialized tools: special needs trusts to protect a disabled heir's benefits, spendthrift trusts to guard against a divorce. You do not buy a dozen trusts. A good attorney builds one plan from the whole tool belt fitted to your family. One fear stops people from ever using an irrevocable trust. The word itself, irrevocable. People think, if I lock my farm or my savings away, and 10 years later the law changes or a crisis hits, I am trapped. You are not. Missouri builds a door into the fortress. A non-charitable, irrevocable trust can still be modified or even ended two ways. The settler and all the beneficiaries can agree to change it, or a court can order changes when unanticipated circumstances defeat the trust's original purpose. It takes real legal work to open that door, but irrevocable has never meant impossible. So the question is yours. Missouri's trust law can handle almost anything you need it to. Do you want to be the captain of your ship today with total flexibility, or the architect of a fortress for tomorrow with total protection? In Missouri, set up a consultation, in person or on Zoom, at nemolegal.com or call 660-956-4502.